We look forward to an interesting presentation by Professor Gabor Hulko.
Thank you very much.
Professor, please.
I'm here. Do you hear me?
Yes, I hear you.
Oh, thank you. Thank you very much. I prepared also a short presentation on the matter. I will try to share this with you. Do you see this? May I ask?
Yes, I see. Very good.
Yes, definitely. First and foremost, I would like to thank you for having me. It is very good to get in a quasi-personal way, Professor Vielec. I heard quite a lot of you. I am an associate professor at the Faculty of Law of Széchenyi University in Europe, and as you probably know, I joined the working group on the last moment, but I try to live up to the other presentations which were defined before me. I prepared a short presentation or an overview of the regulation in Slovakia regarding the social media platforms and regarding the internet. And basically the structure of my presentation is that first and foremost I would like to talk a little bit about the legal regulation or the sources of legal regulation which are connected mostly to the internet regulation in Slovakia, but also in some part of the social media platforms. Also I would like to point out some general principles and one case from the Slovak legal system or the Slovak regulation, which deals at least approximately or a little bit with the social media regulation or freedom of expression. Furthermore, I would like to talk a little bit about the trends and tendencies, what we can await or what we will see in Slovak regulation, or what we can presume will happen in Slovakia, and about the challenges of the regulation of social media in Slovakia, if we can speak anything or if we can add anything about it. And I could freely connect to Professor Koltai, who said that the Hungarian regulation is not particularly interested in this matter. The Slovak regulation also has this flow. I mean, there is basically no special regulation which is dealing with the issue of social media or the connection of social media and freedom of expression. Well, the basis is, of course, the Constitution of Slovakia, which is more or less the same in this regard as the Constitution of the Czech Republic, and which also already Professor Rozehnal explained, that the freedom of expression and the right to information is guaranteed, shall be guaranteed. Furthermore, everyone has the right to express his or her opinion and disseminate ideas and information freely. So these are the basic rules of expression, freedom of expression, and the right to information. The third rule is very, very important, that the censorship shall be prohibited. No censorship is allowed. But the main context of the constitutional regulation of Slovakia deals with the censorship from the part of the state. So it deals mostly with the part of the state censorship. Well, this is a common thing, I think, in the post-socialistic states, where the censorship in the previous years or before the change of the regime was typical for the state. But of course, this does not mean that only state censorship is prohibited, because also private censorship shall be prohibited. Also, private censorship is not allowed in the Slovak regulation. If we see, or if we try to check the conformity of the Slovak legal system with the EU law, the same can be told, which is the case of Hungary or Czech Republic or Poland, that Slovakia is a member of the EU. Therefore, the basic outlines, the basics are the same. Of course, we have a GDPR. I mean, in Slovakia, we have a GDPR, and the most relevant legal sources, I think, from this perspective, are the directive on audiovisual media services, which was already mentioned, and the directive on electronic commerce, which was also already mentioned by the previous presenters. As to the AVMSD, the Directive on Audiovisual Media Services, the latest change of this directive was not yet implemented in the Slovak legal system. It is in the legislative process. It is at the Ministry of Culture. They are preparing some materials, but there are several documents which are discussing that it should be implemented. However, it is not implemented yet, and the media news are talking about an upcoming regulation on this or in this branch, but the government is talking about, or the governmental sources are talking about, a global new regulation on media in Slovakia. And of course, the directive on electronic commerce was implemented several years before with the Act number 22 of 2004 on electronic commerce. I will quote that as e-commerce act in the following. So when we check the internet regulation in Slovakia, this is generally the internet regulation or statutes or provisions which are dealing with questions regarding the internet. There are, or we can say that these are the main bulk points of regulation. Of course, there is an aspect of personal data protection, the GDPR. There is personality rights, protection of personhood, which deals with basically the civil code, Article 13 and 11, 12 and 13 of the Slovak Civil Code. Of course, there is intellectual property, trademark, copyrights, which we could hear also about the previous or former presentation. There are some aspects in the penal code, especially I quoted hate speech because the Slovak regulation does not recognize this hate speech. There is no legal definition of hate speech. Of course, incitement to violence, incitement against community, and similar criminal activities can be subsumed under the hate speech or this method. Therefore, I wrote that hate speech in company because there is no legal definition of hate speech in the Slovak regulation. There are some rules about political campaign financing, namely that some of the but not from a freedom of expression part, but mainly from a financing that financing media ads in social networks should be also calculated into the political campaign financing. Of course, the e-services and e-advertisement is regulated by the e-commerce act, which I was talking about. And some relevant stipulations and provisions are also found in the media law, press law, so in the branch regarding media services. But this is a general scope of the regulation. I mean, it deals with issues which are connected to the internet services, or can be also have a dimension of internet type services, but there is no special regulation. Therefore, I wrote that there is no lex specialis for social media platforms exclusively, or some regulation which deals with at least some of the important issues like freedom of speech, censorship of the social media platforms in this regard. So the closest thing what we have in Slovakia to the social media platform regulation is the e-commerce act, which is basically, which I go back a little bit, which is basically the implementation of the directive on electronic commerce. So the E-Commerce Act states that the provider is not responsible for the transmitted information. Only in cases that he did not initiate the transmission, did not select the recipients of the information, and did not combine or modify the information. So basically, this means, or this is the situation which is quite general, and also the Czech Republic Czech regulation is very similar to this, because the provider shall not be liable for any information stored at the request of the user. Of course, under the condition that then it takes immediate action to put an end to users' unlawful conduct. So the baseline is, if we would like to summarize what the E-Commerce Act says, the general idea is that the service provider, in case of social media, of course, the social media provider like Facebook, for instance, or Twitter, that is only responsible for the content it stores or transmits if it has become aware of its illegality and has not acted against it, so it remains passive, or if the service provider has had a significant influence on the compilation of information. These stipulations, these provisions are basically a transformation of the e-commerce directive, Article 14 of the e-commerce directive, into Slovak law with no substantive changes. And therefore the larger groups of service providers cannot be liable for information, or only in a very cumbersome way what they store or transmitting. And this is more or less in accordance with the ruling of the European Court of Human Rights, the Delphi AS versus Estonia verdict, which basically deals with the same regulation. Furthermore, if we take a look at various provider obligations, it has to be stated that under law in Slovakia, the provider has no obligation to monitor the content, but has and also has no obligation to actively search for illegal content. So there is no content tracking. The content tracking of persons is basically illegal in Slovakia, but if the provider becomes aware of the illegality of the information, it shall remove this, or at least prevent access to it. So generally that means that the content provider has no active role, except of course no active role in searching for the information, but if he finds the information unlawful, then the provider should remove this information or prevent access to it. Of course, there is a question how to prove the illegality of the information. Does the subsumption or the idea of the provider is sufficient of the illegality of the information, or there has to be some ruling, for instance, a court ruling, which declares that the information is unlawful, the information is illegal. So this is a major point. This is one of the major points of the regulation. So if I would like to summarize the basis of the social media regulation, which is derived from the E-Commerce Act, as I explained it lately. There is no common legal position on the regulation for social media platforms in general. And as for intervention, the E-Commerce Act is used, or the E-Commerce Act is applied. There is, however, one case which are highlighted here. This is the case of Stacho versus Klub Strážov, where a comment on a website that violated human dignity of a specific individual, and this was this is more or less the case of social media in Slovakia also, because it was not the article which was violating human dignity, but it was a comment, a user comment, an anonymous user comment which violated his rights. So the plaintiff sought an apology from the operator, so the operator of the website, the removal of the post and the images in the height of 5,000 euros. The court in the second instance, the court in the first instance ruled in favor of the plaintiff. So the court ruled that the information, the comment should be removed, and he ruled in favor of the images also. But the court in second instance ruled in the favor of the plaintiff only regarding removal of the post and dismissed the remainder of the action. So the court on second instance told no damages allowed, no damages will be paid out. And the case is at the moment at the Supreme Court of Slovakia. We await the outcome of this court because there is a relevant consideration that this is not in accordance or not or a little bit in conflict with the Article 13, paragraph 13 of the Civil Code, which states that a violation in human dignity, when we are in this case, the violation should be removed, and that an adequate satisfaction should be given to him or her. I will deal with this matter in more detail, of course, in my chapter. But this is quite an interesting question in Slovak law, whether in such cases only the removal is relevant, or whether also the damages should be paid out by the operator by the website, for instance, for the operator of the website. And also, which is not on the slide, but as I was listening to other presentation, came to my mind that in the last years or last period, especially connected with fake news and hoaxes on the coronavirus situation, the police force of Slovakia has intervened in several cases against natural persons, against citizens, based on Facebook comments which were denying the coronavirus or trying to make a hoax of this coronavirus situation. But this is more a special thing, not a general rule. If we would like to summarize the general principles of regulations, basically, in the regulation in Slovakia, there are two decisive issues, but this is more or less the same in the Czech Republic, also in Hungary, that there are disputes and legal liability between the users, and there is the liability of the platforms, of course. The bottom line is that the Slovak regulation does not distinguish between online and offline forums, so it is not relevant through which medium the expression of opinion takes place. And as to the legal procedures, they are the same as in the offline world, but the specifics of communication and social media platforms must be considered when investigating an infringement. Also, if we see or if we try to take a look on a theoretical level to the state of the regulation in Slovakia, we can see that there are some infringements which are based in private law, mostly in civil law, like right of privacy, interference with some personal data, violation of human dignity, privacy, or defamation. And usually between individuals, between users, it is usually settled by court procedures. From a public law point of view, we can distinguish basically the administrative sanctions or administrative type violations, administrative type infringements, and criminal law-based infringements, which fall under the category of hate speech, or usually fall under the category of hate speech. And as I told before, or in the beginning, there is no such term as hate speech in the current Slovak regulation. When we try to research a little bit of the layers of regulation, I mean, from the point of view of possible action, what I can do or what I cannot do, there are basically four layers which I can differentiate. There is the user versus user connection, which is basically from a civil law point of view, and the possible action between the users can be court or some administrative action. The user versus state, mostly hate speech, mostly criminal acts where the state intervenes, the state steps in. But as I told before, there are no special actions or no special proceedings according to hate speech or criminal acts committed on social media platforms. The big question is the user versus provider and the provider versus state question, or the big questions are more or less, because at the moment the user versus provider relationship is under Slovak law considered as a civil contract. Yes, so there are provider terms, of course, there are provider policies, or theoretically they can go to court if, for instance, a user content is removed, or it is a case of alleged censorship from the social media platform. But there are no court cases which would deal in Slovakia with this manner. And the last thing which I wanted to point out in these layers of the possible regulation is the provider versus the state. Of course, some part of this relationship I covered with the e-commerce act of in Slovakia, but not everything, because the status and the functioning and the aim of social media platforms is absolutely different than a classic definitions or the classic regulation given by the e-commerce act. Now, when we talk about or think about the future trends in Slovak regulation, we can say quite surely that there will be no long-standing Slovak regulation in this matter. So there will be no such regulation as it is planned in Poland, for instance. I think that it is quite sure, not only based on the reason that there is no general concept at the legislator or at the government how to handle the social media platforms. Though there are several political statements that social media platform needs some kind of regulation, the current situation of the Slovak government is a little bit different than it is in Poland or than it is in Hungary. And I do not want to speak in political terms at the moment, but the current political situation in Slovakia will not. I think it is not a priority problem for a regulation on this matter. So there is no general conception, and also the implementation of the AVMSD directive is before us beforehand. So we can reasonably presume that the Slovak legislation will wait for a European model regulation, and then we'll try to implement the European model regulation in the Slovak law. However, there is a basic question that where will this European regulation go, and therefore I would like to talk a little bit and very briefly about problems and conclusions on these European regulations, because it was pointed out by Professor Popovic, if I recall it correctly, that there is not only the European aspect of social media platforms, but there is only the United States aspect of social media platforms, and the current applicational problems of social media platforms, and also I do not want to talk. So this is connected. This is interconnected. So without a view to U.S. regulation, I think that the European regulation cannot cannot be effective. This is one point which I want to make. And the second thing is that I would like to talk two relevant issues which I see. Of course, there are more issues connected with social media platform. Professor Rozehnal detailed it from a philosophical, theoretical point of view, and also I'm absolutely aware that the filter bubble, user profiling, user data leaks, or user data misuse are also major issues of social media platform. If we talk about the Cambridge Analytica issue, but there are from last year there are, or basically one is from this year, there are two major points which are practical, which have practical relevance. One is the Hunter Biden case, where the social media restricted access to news. Twitter, for instance, banned sharing news in private concerning Hunter Biden's case, and the response from Facebook and Twitter was that Communication Decency Act, yes. So it's not our responsibility, and also they involved, or they were making claims that they have also the right to freedom of speech, to the First Amendment, to the Bill of Rights, and this is basically a major issue, because there are two freedoms opposing each other. My freedom of speech and the Facebook's freedom of speech, or the social media's freedom of speech. And while we can have equal rights, but our possibilities are not equal in any way. So there is a basic question if corporations should have freedom of speech, or if they have freedom of speech, in what extent should they have? And this does not apply only to social media platforms, but the most important is in case of social media platforms, because the censorship, or the alleged censorship from social media platforms, can be disguised as their freedom of speech. Or at least in the United States, it is quite a relevant issue. So we have to deal with this also in Europe. The second thing, or the second issue, is also is connected the troubling amount of power over online speech, which I will not go into detail, because Professor Popovic already discussed this matter, and I think that it was very relevant. And also Professor Rozehnal mentioned this. The second thing is the banning of Trump's Facebook account, which happened in January this year. And we can like Donald Trump, or we do not have to like him, but in the end, it is quite an interesting, or raises a quite interesting question of effectivity and speed of state intervention, because normally, or normal administrative procedures, normal court procedures will be not enough to compensate, or it has to be a very quick response from the state in case of censorship, or alleged censorship from the public, from for instance Facebook or Twitter. This presumes that the state will have means to react to unlawful conduct of social media platform within 24 or 48 hours. So on very short terms. And if I recall it correctly, the Polish regulation tries also give a time limit, a very strict time limit to state intervention. This is the first part, and the second part, which was pointed out also several times during the previous presentations, that the effectiveness of the internal control, the so-called Facebook Supreme Court, how effective it is, because lately the Facebook Supreme Court, or the oversight board, ruled in this case, or banning Trump's Facebook account, and told that suspending Trump's account was not in accordance with Facebook's policies, because it shouldn't have done so for an indefinite period, because such suspension is not outlined in the site policies. So basically, the Facebook Oversight Board told us that it was not the right procedure from Facebook, but in the end they told also that that Facebook has to apply and justify a defined penalty in the next 6 months. So basically they said that the account which was banned in January, that it is not very good from, or it is not absolutely in accordance with Facebook's policies, and they gave Facebook another 6 months to react to this situation. So basically, this is a situation which is not effective. I don't really think, and this example I think illustrates very well what Professor Koltai and Professor Popovich told, that the Facebook Oversight Board cannot be effective, and they do not have very big faith in this, and neither do I. So these are basically the two main issues which I think that the European regulation or a model European regulation should solve. But in the end, I think it is always a very interesting legislative question which way the European regulation will go. Thank you for your attention, and thank you for your time.
Dear colleagues and friends, our conference is finished. Conference time passed very quickly. At the end of the conference, I would like to thank all the participants, speakers, and guests who took part in events. It was a pleasure to be able to attend meeting with you. I think it was very useful to look at the phenomenon of online censorship and fake news from different sides of view today. As I said, this is only a part of results achieved by our team. There is still a lot of work ahead of our research group, and we will slowly implement it. Once again, thank you very much for the Professor Ede Silagi, Director of Institute of Comparative Law, Ferenc Mádl in Budapest, for your presence and support. So I officially close our conference. We will in touch. Good luck, good health. Bye.